Hello, everyone, and welcome to Sterling Live. Happy 2023. This is our first episode of the year. I am so excited to be back on Sterling Live with all of you. My name is Caitlin Brower. I am Sterling's social media manager and your host for Sterling Live. And on our first episode of the year, we have with us today Angela Preston, Associate General Counsel, Corporate Ethics and Compliance, and Chris Christian, Director of Compliance. So I'm so happy to have both Angela and Chris with us. They actually kicked us off in 2022 for Sterling Live, so they're here again to kick us off in 2023. As you can see on the bottom of the screen, our topic today is 2022 background screening compliance in review and what you need to know for 2023. Chris and Angela, thank you both so much for joining me today. I would love to give you a second now to introduce yourselves to our audience. So Chris, I'll start off with you. Can you please introduce yourself?
Sure. Thanks for joining, everybody. So my name is Chris Christian. I am the Director of Compliance here at Sterling. I'm actually one of several directors of compliance, and I work with Angela, and I track a lot of the things that we talk about, that we're going to talk about today, that we talked about in our webinar back in December.
Awesome. Thank you. Angela, can you go ahead and introduce yourself to our audience?
Sure. Hi, everyone. I'm Angela Preston, and I am, as Caitlin mentioned, Associate General Counsel here at Sterling. I'm head of compliance. I've been practicing law for, a long time, 30 years or so now. I've been in this industry for over 20 years, focused on legal and compliance issues around background screening. And I'm very happy to be part of the Sterling team and here to engage and dig into some of the highlights from last year and what we need to be thinking about since it's already, the middle of January into the new year. So I will turn it over to you, Caitlin.
Yeah, so 2 weeks into the year, it's already January 19th, which is crazy, but we've got a ton of great stuff to talk about today. Before we get into it, I do want to remind our audience, if you are watching live on Facebook, LinkedIn, or YouTube right now, if you have questions for Chris or Angela throughout the episode, you can go ahead and put them in the comment section across all three of these platforms, and I will get them over to these two as I see fit throughout the episode. So again, we are talking about, background screening, compliance, and review from last year, but then what you need to know this year. So our topic today actually stems off of a webinar we had, feels like forever ago, all the way back on December 8th. The two of you joined us for a webinar, and it was really informative. We talked about a lot of stuff, and unfortunately, our audience gave us some really good insight after the webinar and, the topics that resonated with them, what they want to learn more about. So we're going to dive into a lot of those key themes and topics today. The first thing I want to touch on, though, is that we actually polled that audience that day. We asked them two separate questions and got some really interesting answers. So I want to give you both the time now to kind of provide, what you're thinking around these results. So the first question we asked our audience that day was, have you changed your screening policies in 2022 based on a change to law or regulation? Here are the results. 57% said no, we haven't changed our policies. 28% said yes, our drug screening policies have changed. And 15% said yes, our criminal background screening policies have changed. So looking at that data, from December 8th, now it's January 19th, what are the both of you thinking? Angela, I'll come to you first here.
Yeah, so I'm curious if, how many attendees would have changed their answer at the end of the webinar, but we didn't ask them again at the end of the webinar. But I guess that just the what we wanted people to kind of start thinking about was, you need to review these policies periodically. You need to look at things that you're using in the context of, what's changed in the law. Are there things that we maybe culturally used to be concerned about and we're less concerned about today? Unless you're like in a regulated industry or safety sensitive positions, there may be changes in the law that make you want to reconsider your matrix? How are you evaluating or adjudicating your screening reports? Are there, not just in the drug context, but in the way that you're looking at criminal history, and with more and more states adopting in the box, fair chance, clean slate, which we're going to talk about, which is the newer category.
Mm-hmm.
All of these things, how are you changing the way that you're evaluating your applicants in light of these new laws? So I guess I would just use this as the moment to say, yeah, it's January. You've got a fresh slate.
Yeah.
You're doing your work plans. Make that part of your plan to go back and reevaluate your background screening policy, your adjudication of your applicants. What are you doing to individualize for individualized assessment of your applicants when it comes to criminal history? And how do you maybe need to change your drug program in light of new laws?
Right. Chris, what are your thoughts on this data set that we got from the attendees?
Yeah, hard to top what Angela just said. I think what I would add is, yeah, we're at the beginning of the new year, and for your planning purposes, probably this, policy review, your screening policy review should be probably at that first quarter, because if you don't fill up your calendar now, somebody else will fill up your planning calendar for the year. So that happens to me all the time. So I would say, yeah, if you haven't put this on the radar, I would say first quarter is the time to do it. I would also say too, like you may feel like, and this is just a guess, but there might be people who think that their policy is fine, and that maybe you've monitored and you've seen some new ban the box laws come out, or some kind of drug law come out, and you've checked your policy. But I guess I would say, have you accounted for new topics that Angela kind of pointed out, which we'll talk about a little bit, like clean slate? That might not hit your radar as a background employer screening law, because they're not written that way, and we'll talk about it more. But maybe there's some new topics that you should be adding.
So the other question that we had asked our audience, so we wanted to find out, how their organizations are tracking new background screening laws and regulations. So 41% told us that their internal staff conducts tracking and monitoring. 38% said they rely on outside counsel or a background screening company. And then 21% said our in-house legal department relays when laws change. So Chris, I'll stay with you here, just initial thoughts on, what our audience was telling us.
Yeah, I'll say it again. I found the 41% of internal staff doing this. I found that surprisingly high for me, but hats off to those people that do that, because I do it, and it's a lot of work. I think that's great. I think a blended approach sometimes is helpful, because I think there's always nuances, and there's sometimes you miss something. And so if you're relying on maybe outside counsel or a trade industry that also tracks things, I think you should look to leverage other areas if you're doing it in-house. But I think, yeah, that's a pretty high number, and that's impressive, quite frankly.
Yeah. Angela, what are you thinking on this data set here?
Yeah, I mean, I think that maybe our webinar attendees are above average in terms of their awareness. So it's impressive numbers. I would say one thing, that if you're using a tool or a tracker, there are tools out there. And I mean, Google Alerts is a tool also. So, I mean, I don't minimize that at all. It can be as simple as setting Google Alerts. But check your keywords, because we have these new categories of laws, and the buzzwords keep evolving, and things like automated decisioning tools, you would never think to maybe have had that sort of flagged in your Google search or in your legislative tracker before. So go back, revisit your keywords, how you're tracking, update it for the new technology and the new language that we're using, the new terminology around this stuff, hopefully that we introduced for you in the webinar.
Right. Well, back on the webinar, and obviously that's a big theme for everything we're talking about today. We got a lot of great insight from it. So very much we appreciate doing those, for our audience a lot. So two major things stood out to us in the webinar, which what the attendees were telling us that, that's a hot topic. We want to learn about it. Keep it coming. So we're keeping it coming in two areas here. We're going to talk about marijuana laws and clean slate legislation. So Angela, I'll start with you with marijuana laws. So there's a couple of questions I have here for you. The first one is just, at a high level, can you give a quick explanation of what is currently happening with federal law and state law? And, clearly we were talking on December 8th. I don't know if anything has happened over the last couple of weeks or so.
Yeah. So, at a high level, I think we can say that at the federal level, nothing substantive has changed since the last time we talked. At the federal level, cannabis remains classified as a Schedule I substance under the Controlled Substances Act. And so it is, unless there is, some express prohibition on testing, marijuana testing is appropriate. And it, particularly if there are things like reasonable suspicion of impairment, if you suspect use at work, if you observe signs of impairment at work, if there's a workplace accident, all of those things, it is still a controlled substance and it is still something that is, generally speaking, legal to test for. With that said, what has changed and continues to change is really at the state and local level, where there are a number of states that have approved or legalized medical use of cannabis and non-medical recreational use. 37 states that allow for medical use and 21 states that allow for non-medical use, plus territories in the District of Columbia, and new states that were added in 2022. So it continues to be dynamic as in terms of at the state level where some level of use has become legal. Mm-hmm. And some of those states, there are protections for employees in the workplace protecting those forms of legal use. So you have to really be up to date on a state or local law that might impact your workplace, where there might be protections for your workforce, because the state law provides a level of protection for your employees under those laws.
Well, going off employment protection, are you seeing that is a trend in that law extending or maybe expanding in that area, and mainly for medical and recreational use?
Yes, we have seen that expand, and not only just in the context of the actual statutory black letter law of the state, but also in the case law, because we're seeing employees who are potentially terminated for use in the workplace, and they're defending, themselves and fighting termination based on relying on their medical card or medical use, which is allowed in their state. And we're seeing employees win those cases. So I think that we are seeing the trend there sort of move in favor of employees. So employers, it's not that employers can't continue to run their drug-free program and include medical or include marijuana in those tests where allowed, but you need to understand where you need to make accommodations for medical or off-duty use. since there are so many jurisdictions that allow off-duty adult use, medical use, you really need to kind of reevaluate what is the job-related situation that you're trying to prevent, whether or not it's safety-sensitive positions, where impairment, there would be a high liability, or where you are regulated and you are not permitted to allow it if you're a federal contractor. Considering all of those things in light of what your state or local law provides. I will call out, California, Connecticut, Montana, Nevada, New Jersey, New York, Rhode Island. They are all states that have laws protecting off-duty use and that provide protection at some level. So if you are in a location that has legal protection of certain types of use, it might be covered by an exemption. Like I mentioned, safety sensitive positions, drivers, machine operators, or it might be required under a federal law. But if you're not in one of those categories, you really need to understand the impact of the state or local law.
So with that trend of, this employment protection, specifically with, off work hours use and everything, do you see, is anywhere like pre-employment drug testing, like as a whole, like prohibited anywhere?
Well, New York City and Philadelphia have laws that prohibit pre-employment drug testing. That does not mean that you can't test for impairment or if you are in an exempt situation. So, but yes, I mean, so in terms of pre-employment screening, New York City and Philadelphia are prime examples, and there are other states where there are other laws that have an impact as to whether or not you can consider possession of marijuana or other things like that in terms of using that in an employment context. So it's not just the drug testing aspect of it, but also the fact of whether or not you can consider a criminal activity related to marijuana possession in your hiring evaluation. The state of Nevada, is a little bit nuanced also because it prohibits an employer from taking adverse action for a positive marijuana pre-employment test. So again, these are nuanced laws, and there is no one standard, and it really behooves you to get with your legal counsel and drill down on, if you are screening, what positions do you screen for, what are, any sort of exemptions or allowances that you want to make, or how does that impact what you're doing with your workforce. And those are decisions that are not only legal decisions but also cultural, and how it fits with your people and culture, and your human resources department getting involved in those conversations as well.
Yeah. So with that being said, as we move like further into 2023, and the two of you had stressed, let's look at our policies, let's make that a priority. What are just some, key things right now, Angela, that you would prop up in regards to, marijuana laws? Like, are there some new ones from 2022 that you need to take note of right away, right now, or just anything else that, employers need to look at?
Yeah, I think the new trend, just to sort of wrap up the marijuana conversation, I know we have other topics. California, AB 2188, which prohibits discrimination in employment based on the use of cannabis. It bars employers from penalizing workers for off-duty use of marijuana. And what the takeaway from this new law is that it presumes that an employer is going to have a reliable method to test for impairment in the workplace. Because if recreational use is allowed, you can assume that, what they do off duty is fine, but they can't be impaired on the job. And that implies that there is a means of testing for that. So now a lot of the big focus in the industry is how are we going to test for impairment, and a focus on new types of tests and turning to new testing methods. So keep an eye on that as far as, ways. I think there's a lot of innovation going on out there, and there are new tests on the market to allow for more targeted testing for impairment. But that's one of the challenges. Rhode Island passed a law last year, Maryland, Missouri. Those are the states that have, sort of the newer laws, but we'll continue to keep you informed. And the only other thing I would mention, just in closing on this topic, is the presidential pardon that we covered in the webinar. I think everyone's aware now that in October, President Biden did state that he would issue pardons for everyone convicted under a federal law for a simple marijuana possession charge, which is sort of a very narrow, specific pardon, but it's important. It sent a very clear message of the direction that the federal government is going on this issue.
All right. Well, a lot there for sure. So thank you, Angela, for going over all of that. Chris, I want to swing it over to you because I want to start talking about clean slate legislation. So to start, what are clean slate laws?
So that phrase coined, clean slate, really refers to a legislative policy model designed to provide relief or opportunities for individuals with a criminal record. Another way of saying that is essentially the goal is that it's to really remove the stigma that's associated with a criminal record after a person has served their time, right? And so I think an important part of this discussion that we didn't get too much into the webinar when it talks about when we're talking about what are clean slate laws. I think it's important. I want to emphasize that there are a lot of variations of these laws, and so they don't all look the same. There's many flavors, if you will, and I think the ones that we focus on and that we're raising today really are those clean slate laws that remove criminal records from public record systems, state repositories, or a county repository. There are some variations that have nothing to do with that. They're simply a reinstatement of a person's civil rights, so the right to vote, or purchase a gun, or something to that effect. And so I want to make sure that the audience understands that if you hear that, right, like you need to dig into the details a little bit and understand there's very nuanced variations of clean slate laws.
So with like the nuances, and you said there's a couple of different examples. What are some examples of some states that have enacted clean slate legislation? Yeah,
so I think the last stat I had looking back in around October, November was there was 28 states roughly that had passed some kind of variation of this law. States that have passed clean slate laws that impact what we're talking about, removing a person's criminal record from the government systems, would be like Arizona, Colorado, which Colorado is, I think, the latest, newest one that was passed in 2022, California, Michigan, Oklahoma, North Carolina, Pennsylvania, Utah, Virginia. Those are some of the ones I can think of off the top of my head, where they've had some variation. And when I say variation, I'll delve into that just a little bit more. Yeah. So some of the laws allow for what's called a petition-based process, where an individual who has a criminal record, the state law essentially allows them the ability to petition a court, pay a fee, fill out some paperwork. They may have to probably get an attorney to help them with that process. I'm sure the process isn't very easy sometimes for them, right? But if it is, essentially it's kind of paving a path for the person to petition the court to remove a record if certain types of records are available. or eligible, sorry, to be removed. I think that's and going on that topic, there's also another variation of this, which is for records that are eligible to be removed. The laws differ on what types of records. So it could be just a minor misdemeanor marijuana charge, for example, is eligible, but a felony, record might not be. So there's, like I said, there's variations. Some of these, and this is kind of the newer trend that we're seeing, is that there's now more of a focus on some of this legislation to automatically remove records. So eliminate or just bypass the petition-based process, which is a lot of critics of that process. It's costly, it's time-consuming, it's not very fair to the individual. But instead, the state just automatically remove these records, via processes that they've set up.
So with the variations and, some states doing this, some states doing that, some states actually not even, doing it right now. What are just 3 things organizations need to consider when it does come to clean slate legislation?
Yeah. So I'd say the first thing, and this is kind of going back to the second poll question about monitoring legislation. So if you're monitoring legislation, say in-house, internally, Angela made a very good point. These the key words that you use, you might not find clean slate. We're using the terms clean slate because that's just kind of a general terminology that's been put out by some advocacy groups. But really, this falls under what's called criminal record reform or criminal justice reform. I'm not saying that's the magic term. I'm just saying, like, you're probably not going to find something about background checks, screening, because these laws really aren't that. These aren't employer laws. These are laws designed for, government institutions within the state to address criminal records in the system and for the individuals that hold those records, right? So when it comes to monitoring legislation, you should be monitoring legislation. But in order to kind of track these things and make sure they're hitting your radar, have a look at some of these laws, the historical laws, and see the language, look at the language and the key terms in there so you can help define some of your key terms going forward, because clean slate is probably not a term that might get you there.
All right.
I'd say another thing is we talked, again, it goes back to the very first poll question, which is the policy. So you should be looking to modify your policies if you don't know where to start. And clean slate is a new subject, so I would say before you just start going and modifying your policy in regards to clean slate laws, I think you need to probably have a conversation with your legal counsel, whether it's in-house or outside counsel, about what impacts are these laws going to potentially have on you as an employer who does background checks, and work through that and try to get a better idea of the bigger picture of where these laws are taking shape across the country, and what should your policy look like. I'm not saying that you need to change your policy. I'm just saying that you need to think about what these impacts are before you start just changing your policies. And then I guess to dovetail off of that, I've already said it, which is before you do any changes, you should obviously always be reviewing your program and making changes with your legal counsel, kind of side by side with you before you make those changes.
Absolutely. So we got a ton of engagement throughout the webinar that we had in December. A lot of our audience members were asking questions. They were curious about certain other areas and everything like that. So I did go back and I looked at 2 questions that stood out to me that I think would be, good for the 2 of you to give some information around for this audience on Sterling Live today. So the first question is, has there been a trend in FCRA class action lawsuits dealing with pre and or post adverse action? So Angela, I'll start with you here.
Sure. Yeah. So we continue to see litigation. It's really the litigation that we track and monitor what's going on out there in the courts with respect to enforcement of Fair Credit Reporting Act laws and state analog laws. As far as FCRA litigation, it continues to be an issue. It is a very technical statute, and the question really focused on pre and final adverse action notices, which is a very specific technical process that's defined under the statute. So yeah, we continue to see those cases that the process was not followed properly, or one or both of the notices were deficient or not sent. So yeah, we continue to see those things. Also, the other technical issues around the statute, things like disclosure forms and the disclosure and authorization for a background check. We continue to see cases on that. So this is always a good reminder to go back and review your forms, update your forms. Think about how you are maybe modifying your forms to adapt to your particular location or need. Even beyond the Fair Credit Reporting Act, there are state and local laws that have additional notification requirements. But your basic FCRA disclosure for a background check, authorization for a background check, and pre and final adverse action, it's always a good idea to routinely review those forms and make sure that they're up to date. Review them with your counsel, and review your process to make sure that it is up to snuff, and so you're not the next target for the next class action.
And one other question that had come in during the webinar, and I do think this is particularly timely. It's around, what do employers need to know about running criminal checks in LA County? So we're looking at, the redaction of PII and then the legislation that was not passed last year. So what are some things that employees, need to know? Employers, excuse me.
Yeah, we did. We covered that in the webinar. We hit on it as, one of the things that didn't pass last year was the legislation that industry groups had, lobbied for and supported. That actually the legislation passed, but it ended up getting vetoed. And it was the legislation that had been introduced in the state of California that would have made full date of birth and other PII part of the public record as a matter of law. And right now what we see is some courts are redacting date of birth information based on an interpretation of some case law that is making it much more difficult to get all of the identifying information that we need from the court in order to match a court record with a candidate. So without access to a date of birth, it's much more difficult, and it takes longer in order to determine whether or not a case record, some record of a criminal activity that we find in the court record is a match to the candidate. You can still do checks in California, in LA County, but it makes it much more difficult and makes it a longer process in order to make that determination as to whether or not the record is associated with the candidate, because there is, a need to report that information accurately. So you have to go through the court records to see if there are other identifiers in the court record that you can associate and match and so forth. So yeah, we're continuing to fulfill searches nationally in every court. But I would say to employers and clients who are out there, this is a challenge. And as long as date of birth and other personal identifiers are being removed from the court record or not being accessible in the court record, it makes the whole background screening process more challenging, more expensive, more time consuming, and certainly can potentially get in the way of having a safe workplace and making sure that you're doing all the right things when you're slowing that process down and not able to get the information you need. So yeah, if I guess I would make a pitch to those out there who are concerned about that issue or listening, if you want to get involved and engaged, we are certainly asking our clients to help us engage on that issue so that we can continue to get full access to to public record information.
Right. Well, those are all the questions that I had for the two of you. I do want to remind our audience, if you are watching live right now, any final questions, please go ahead and send them in. In the meantime, as we wait for any questions to come through, I do want to just gather some final thoughts from the two of you. We had a great discussion today, went over some key areas that clearly individuals want to learn more about, and they do need some more information. So let's just, sign off with some final thoughts here. Chris, I'll hand it over to you first for some final thoughts.
Sure. If I could use a catchphrase, it'd probably be hold on. I'm sure 2023 is going to be exciting and frustrating and challenging for employers and background screeners. But I think, these topics that we've just these two topics, and there's others that we covered on the webinar, I guess they're not going away. They're going to get more complex. We're going to see them more often. And eventually we'll probably be talking down the road about another new topic. Clean slate's the new thing, but who knows what will be the next new thing that we have to deal with. So change is inevitable, but update policies, review your programs, the things that we've been harping on over and over. It sounds like a broken record, but those are the best ways to kind of mitigate those threats to your business.
Yeah, it's a good broken record for sure. And don't worry, we will be back. I will have you two probably again in a couple of months. So you can't run far away from me. I'll definitely have you both back. Angela, final thoughts for our audience today.
Sure. So I think a lot of these new laws and trends that we see are really, there's a common theme of removing barriers to employment, particularly any barriers that are based on potential discriminatory impact. I think the regulators and the state and local governments are very focused on anything that might be discriminatory in the workplace or creating a barrier to someone to get the right to a fundamental way to make a living. So a lot of these laws are really anti-discrimination laws. And I think that is a common theme that we're seeing carried out through clean slate, giving everyone a fair chance, giving everyone a chance to get a fresh start after being incarcerated or after paying their fine or their debt to society or whatever it might have been, to give them a fresh start and not create additional barriers to employment. And it's causing, I think, a trend in other areas as well. Things that we covered in the webinar that we didn't cover today, things like automated decisioning tools that use AI. The whole debate around automation and the use of AI in the hiring process. Really what regulators and lawmakers are concerned about is bias or discrimination in the use of those tools. So we're going to continue to see laws introduced that really are designed, and what's at the root of them is really to give everyone a fair chance and not to have barriers in the process that are based on discriminatory bias. So I think we're going to continue to see that. It's fascinating. It's very interesting topics, and we're going to continue to cover it. We're going to continue to respond to client questions, employer questions, and let us know, what your questions are and what your concerns are, and we'll continue to keep everybody up to date on what we see and hear as the trends as we continue into the year.
We will definitely continue to keep everyone updated. As kind of a wrap up here, some assets for everyone to you'll get after today's live show, and just to point over. So this webinar we've been talking about, it is on demand now. Angela and Chris talked about a lot more information. There was a great deck that they had presented that is on demand. You will see the links across our profiles on Facebook, LinkedIn, and YouTube immediately following this live session. We also have a blog recap of that webinar coming out in the next couple of days. Again, you will see that across our social profiles. And then I'm also going to put a link over to our compliance hub where you can get all of this information, real-time information. Everything is on that hub on Sterling Check's website for all of you to take in. So I will put a link there as well. And there's also an opportunity on that compliance hub. We actually do have a quarterly newsletter that you can subscribe to as well. So again, we're keeping you guys updated. We have so much stuff, to inform you about. So definitely all of that will be there as well. So I want to thank both Chris and Angela for joining me today on this episode of Sterling Live. I want to thank our audience as well. It was truly great. A lot of good information for everyone. So with that being said, thank you both. I really appreciate it. And I will see everyone else next time.
Thanks,
you.
Caitlin.